Hello, and welcome to California Gun Law. I'm your host, Don Hammond, with an update in the CRPA versus LASD case. I know, can I buy a vowel? Yesterday, the court mostly denied the LA Sheriff's Department's motion to dismiss the case on a variety of grounds. They tried everything to get rid of this case, but it marches on. This is good news for gun owners across the state. I'll discuss why. I'm a licensed California attorney and a shooting instructor. I regularly help teach the 16-hour class that's required to get a concealed carry license in California. On this program, we provide education on California's complicated web of gun laws so that responsible gun owners like you can better understand how to lawfully exercise their rights. California has a complicated web of firearms laws and regulations, and there are a lot of traps for the unwary. We want to help you do it right so you won't need our criminal defense legal services. Today, I'll discuss a recent ruling in the pending court case, California Rifle and Pistol Association versus the Los Angeles Sheriff's Department. There are several other plaintiffs in the case, including other organizations and some individuals who have sued the Los Angeles County Sheriff's Department. The claims include long delays in processing CCW license applications, excessive fees, improper denials, and the unavailability of non-resident CCW licenses. In addition to the Sheriff's Department, the plaintiffs have sued Sheriff Luna himself. He really tried hard to get out of the case as an individual, arguing that he's a state actor for purposes of CCW license applications. However, the court kept him in because it's his individual policy that is causing delays and improper denials. The Sheriff's Department also argued that they are immune as state actors, but that didn't fly. When a local department is making decisions about applications, they are acting as local agents, not as state actors. So the judge said that state immunity does not apply. The defendants also tried hard to squash the entire lawsuit, alleging that the organizations, including CRPA and Gun Owners of California, lacked standing to sue over the denial of individual license applications. The judge said the organizations absolutely have standing because all of their members are suffering the same harm, delays and improper denials of CCW license applications, especially with respect to non-residents. There's no need to look at individual claims to determine whether there's a violation. So this is really good news that each individual who's harmed by delays and denials doesn't need to file their own lawsuit. The big, well-funded organizations can pool our money, and they have standing to do it on our behalf. So we can get sweeping changes without a bunch of smaller individual lawsuits. The delay portion of the lawsuit centers around Penal Code Section 26205, which requires issuing agencies to process applications within 120 days of receiving the completed application. The Los Angeles Sheriff's Department has routinely been taking over 2 years to process an application. This is a clear violation of Section 26205. The question is, what's the remedy? This court appears poised to issue an order that LASD must comply with the law. Then, future failures will be actionable as contempt of court. This is an early decision in a case that has already brought us big reforms. This is the case that forced the whole state to start issuing non-resident CCW licenses to people who live outside of California. That was a preliminary injunction ruling that took effect in January 2025, and they started issuing the licenses in April. This ruling that the court issued yesterday was regarding the Sheriff's Department's motion to dismiss the case at an early stage. This case will still go on for at least another year at the district court level, then it may be appealed to the Ninth Circuit. CRPA already settled with the city of Laverne over their exorbitant fees and psychological evaluations, and they have a likely settlement worked out with the California Department of Justice pending the passage of Assembly Bill 1078. I know, There's a lot of bad stuff in Assembly Bill 1078 that will be challenged in court, but there are also a few good things for CCW license applicants, such as clarification that a temporary restraining order issued without notice in a hearing is not disqualifying for a CCW license. The federal DOJ has also launched an investigation into the LA Sheriff's Department regarding delays and denials of CCW license applications that may be a violation of the Second Amendment. This ruling in the CRPA versus LASD case represents a big step forward, but there's still a lot of work to be done. We'll keep you updated on the case as it progresses. I'm Don Hammond of California Gun Law, and we'll catch you all next time. Stay informed, stay legal, stay safe.